Hello, everybody, and welcome to the our webinar on the role of the DPO and the steps that you can take to reduce the risks associated with data. My name is Nils Christiansen. I'm the managing partner of DR Solicitors, and I'm delighted that our colleague David Sinclair, who is a specialist in all matters regulatory, but in particular data, will be talking through this this webinar. You're all on mute as usual is the process in these things, but please do put any questions you may have into the Q&A, and we will deal with those at the end. So David, do you want to put the next slide on? So DR Solicitors, those of you who are not familiar with us, I'm sure most of you are, but we are a specialist law firm. We only work with primary care. That's all we do, and we do everything to do with primary care, be that partnerships, disputes, anything to do with properties, developments, leases, changes in the property ownership, commercial matters to do with contracts, changes in contracts, etc., employment, primary care networks, and then disputes. But this is obviously about our regulatory matters, which is what we regard as commercial, and in particular data, which is becoming a huge matter. A few years ago, data wasn't really ever on our agenda, but now it is, and it's changing fast. And David is an absolute specialist in this area, so I'm sure you are going to get a lot out of this webinar. So welcome everybody, and at this point I'll hand over to David. Thank you.
Thank you, Nils. Good afternoon, everybody. Hopefully you can all hear me well enough. If you can't, can you just flag it up in the chat so that we can rectify that? Yeah, everybody seems to be able to hear me. I'll just go back to the title slide. What we're not going to be able to do in the next 40 minutes is teach you how to be a data protection officer, but the purpose of today is to look at some of the key steps around the role of the data protection officer and some of the risks involved to enable you to take steps, if necessary, to ensure that you are fully compliant with that role. And I think it's worth just talking a little bit about the context of the DPO role and why this webinar is pertinent at this time. You may or may not be aware that earlier last year, around May, June time, the ICO, both in guidance and at a conference, stated that in its view, health and social care providers are generally not complying with data protection law. That's quite a strong statement from a regulator. A data protection officer, or DPO, is a key component in your compliance. And it appears that people are perhaps not quite getting that right. As much as anything else. And if you're not getting the DPO element right, the chances are you're not getting other things right as well. And obviously that puts you at risk. So that was a big change. That was something that we weren't expecting. Around about the same time, it became obvious, I think, to those of us that watch these things, that the ICO's volume of work is way beyond manageable. So just due to the sheer volume of work, and also due to lack of manpower, for a whole range of reasons, the ICO constantly has vacancies and it just doesn't have enough people to do the job. So what the ICO has been doing is guiding data subjects towards using the civil courts to rectify any issues, rather than complaining to the DPO, to the ICO and getting enforcement action, which is all A, very expensive, and B, very time consuming. What they're saying is, look, you've got the power to sue a data controller, why don't you use that? And lo and behold, there are lots of claimant solicitors and what we call claims farmers, claims management companies, who are more than happy to take on these claims. And I'll talk a little bit more about that later on. But the position is that both the General Data Protection Regulation, the GDPR, and the Data Protection Act enable a data subject to sue a controller for damages where they have suffered either financial loss, known as material damage, or non-material damage such as distress. And the claims are climbing slowly. The courts took a very dim view of lots of absolutely minimalist claims and threw them all out. But the solicitors are becoming a bit more sophisticated in bringing these claims, and so the numbers are starting to grow again. But more about that later. So because it's essential that you have this data protection in place, if you haven't got your DPO advising you, then this can cause problems. And so I felt it was helpful to perhaps go through some of the key issues in designating and indeed appointing a DPO to help you through that process. I'm also particularly conscious, because I have to deal with them almost on a daily basis, that lots of GP practices in particular share DPOs, and that is bringing problems in of itself. So in the webinar today, we're going to look at 3 areas: the role of the DPO and some of the issues around that, and look at some of the tips or some actions that can be taken when you actually engage and designate a DPO, and then some of the key aspects primarily around recognizing and early management of a claim if you get one, and how involving the DPO can pay quite huge dividends. So starting with that, what is a DPO? Well, importantly, they're an advisor. And I say importantly because what they're not is a doer. Under the legislation, a DPO cannot be involved in any way, shape or form in operating your data protection system, or undertaking the DPO role if they are involved in data processing and data management themselves. And the view of the ICO simply is, if there is a conflict between the DPO's role and other tasks that the individual undertaking the DPO role is carrying out, the ICO's view is you haven't appointed a DPO. You might think you have, but you haven't. And of course, you're then in breach of the GDPR, and that enables data subjects to sue you. So they've got to be there to advise, but not do. The DPO primary role is to monitor and review. They monitor and review the effectiveness of your data protection system and your legal compliance. And importantly, notify you when things are not perhaps quite right, or you've forgotten to do something. And that poses problems if you're, for example, sharing a DPO who's employed perhaps by the ICB or ICS, and you're only using them on an as and when basis. They're not there to advise you when things are not going well. So that's maybe something to think about. Their role is to certainly, as a minimum, advise you on staff training. So what awareness training people need, what specialist training people need. The DPO is allowed to train your staff. And I know lots and lots of DPOs who carry out training. But as a minimum, they should be telling you where the gaps in training are. They also advise on, sorry, excuse me, I'm just having a little bit of a technical problem. They also advise and support the partners or directors, if it's a company, on things like undertaking data protection impact assessments. Now again, lots of controllers require the DPO to carry out the assessment. Well, they can't. They're carrying out the assessment, they're not undertaking the role of DPO. They can't effectively audit or monitor themselves. And that creates a conflict. And where we've got a conflict, according to the ICO, you didn't appoint a DPO. Very important, the DPO is the person who's responsible, and it's part of their statutory role, to liaise with your data subjects, whether that be staff, whether it be patients, clients, the people you support, or indeed members of the public whose data you hold for whatever reason. So as the face of data protection for your organisation, your DPO has to be available. And there was a huge prosecution in April last year. The total sum was 12.7 million. It was a massive company, so don't worry about the sums. But the point was that one of the primary reasons for the prosecution was that the data subjects didn't know who the DPO was and therefore couldn't contact them directly. And that's maybe something that we have some questions on, or we can deal with later. Importantly, the DPO has to be independent. It can't be part of the day-to-day management of patient data, client data, etc. And they must be able to act confidentially. So data subjects must be able to have a confidential conversation with the DPO. The DPO must be able to have independent and confidential conversations with the partners or with the board of directors. And so they must independently carry out their role. Now, do you need a DPO? Well, the answer is yes and no. If you are a public authority, so a GP practice, by law you must have a DPO. On the other hand, if you're in social care, you only require a DPO where you're processing special category, what used to be known as sensitive personal data, as a core part of your undertaking. So in other words, the provision of treatment or care, provided that processing is on a large scale. So if you're a relatively small organisation, it may be you don't need a DPO. You can, of course, appoint a DPO voluntarily, but please be aware, if you do so, then the ICO expects you to follow all the rules regarding a DPO as set out in the GDPR. And so again, that's something that maybe you want to have a chat about. Please feel free to drop me an email, and it's something we can perhaps have a talk about on another day. So the first thing to identify is, unless you're a public authority, do you actually need a DPO? And if not, well, do we want to appoint one or not? Now, there's a bit of an anomaly a lacuna, as we call it in law. The GDPR mandates that every organisation who requires a DPO or has one designates a DPO. Designate means you must name them. And you must name them in terms of, you must tell the data subjects who the DPO is, and you must also tell the ICO who the DPO is, because the DPO is also your liaison with the ICO. And if the ICO intervenes in any way, shape or form, they will expect to be speaking to your DPO, not to one of the partners or one of the directors. So designating a DPO is mandated, but there's nothing in the legislation about how you appoint the DPO, under what conditions, what terms. And generally speaking, organisations forget to appoint them. You name them, and everybody knows who the DPO is, but there's no formal appointment. And this is where I have lots of problems with DPOs. In fact, I had one on Friday where the partnership had never actually formally appointed the DPO. And the DPO, because there's a bit of a dispute going on, is able to turn around and say, well, actually, no, I don't work for you. I'm employed by the ICB. I'm here to help you, but I'm not your DPO, and therefore I'm not getting involved. And that's left the partnership in a little bit of a sticky position. And so it can be disastrous to not get that right.
David, just Nils jumping in. You're on the introduction slide. Is that where you wanted to be?
Yep, still there. So, sorry, should have moved the slide on, shouldn't I? My tech isn't quite working. Yeah. Apologies. Thanks, Niels. So we know who can undertake the role. It's in the legislation. Somebody with a wealth of knowledge and experience about how data is processed in your organisation. They've got to have the experience of working in healthcare or social care. And ideally, you know, in a GP practice or within a care setting. They also need to understand what data you're processing, for what purpose, by whom, how you're keeping it, where you're keeping it, etc. Additionally, and importantly, the DPO must have an expert knowledge, not a wealth, an expert knowledge of data protection law. Please be aware that is much wider than just the GDPR. You must understand how the Act fits into that. Where does the common law come in? How does that tie in with medical ethics or care ethics or CQC regulation? So data protection law is quite a large area, and the DPO has to be an expert in that. Now that's a real problem, particularly for me. I'm a regulatory solicitor by background, so I've done the solicitor's training. I went off and did a master's in data protection law. That wasn't quite enough. That gave me sort of theory. But I then did a master's in data security management, so the physical management of data. And I'm qualified as a DPO. And to be blunt, I wouldn't call myself an expert. Not yet. I've still got a way to go. And yet the average DPO training is 3 days. So there may be an issue. And the issue is that it is the controller that's liable for any failures by the DPO. And that's quite important. The ICO, or indeed the data subject, will come after the controller, not the DPO. And therefore, properly appointing the DPO is extremely important. That said, who can't be a DPO? Well, clearly the partners can't, practice manager or senior managers can't, directors can't, and anybody physically involved in the day-to-day management of patient data, client data, staff data. In many cases, solicitors can't be DPOs, and people appointed by insurance companies can't be DPOs because they're deemed to be conflicted in that they manage as well as review and monitor. So it's worth sitting down and thinking, hang on a second, have we got a DPO? And if so, have we got a DPO? Or are they actually conflicted and therefore we're deemed not to have one? Apologies, I'm not good with the tech today. In law, in particular, in practice as well, I might add, evidence is key. Being able to prove you've done something is everything. You say you've done it and everybody goes, yeah, and show me the evidence. And so, generally speaking, the evidence of an appointment of a DPO is the contract. Whether it's an employment contract or whether it's a contract for services for a third party, it's important to have it in writing exactly what you've engaged your DPO to do, and more importantly, what you've not engaged them to do. And I've put some fairly basics here, but they're all very relevant. Obviously, if it's an employee, then they've got the normal employment contract, and within the scope of work will be their DPO duties. Now, a big issue with employees is, of course, they get promoted, they move around, they change roles. It's important to make sure that that contract is amended and updated to make sure that the DPO element of it is always current. You'll all be aware of, employment contracts being drafted 10 years ago. Somebody's been with the organisation 10 years, and their job today is nothing like the job 10 years ago. So getting the contract right is very, very important. It is even more so if the DPO is a consultant, a third party not employed by your partnership or your company. And some thought needs to be given in either case. First of all, have you got the right DPO for your organisation? Do they have the relevant competence, the training, the experience, the skills and the knowledge to do the job for you? Has the contract got all the relevant terms in it so that they're properly employed, you're not breaching employment law, or indeed you're contracted, they're contracting with you to do a particular job, that the job is set out, what they're not doing is also set out, and in particular, are you able to dismiss or discipline them? The GDPR prohibits a controller from dismissing or otherwise penalising a DPO for the exercise of their tasks. Now, the vast majority of DPOs believe that makes them bulletproof. Can't sack me, I'm a DPO. Nothing could be further from the truth. The law doesn't prevent a controller from taking action against the DPO for failing to undertake the DPO duties. And so if it's a third party, you're going to be relying on the contract to either discipline or remove them, and more importantly, to recover any losses that you suffer as a result of claims by data subjects. And that can be important, again, for reasons I'll come to in a few minutes. Importantly, in contract law, the terms of a contract must be certain. In other words, if it's ambiguous, it falls in favour of the DPO, not you. And therefore it's important that you get advice when you're drafting these contracts or when you're reviewing them and revising them. And that's not to say that you have to go to solicitors every single time you look at the contract, but you do need to take expert advice, particularly in the case of an employee DPO, because of course they've got lots of employment rights that impinge on their DPO duties, and they've got DPO duties that affect their employment rights. And so you need to be certain of those. As I've said previously, as statutory, i.e. ICO enforcement action, and indeed civil liability to data subjects lies on you, not the DPO, then your contract, if it's poorly drafted, is not going to be much help to you if things go wrong. And so it's worth making sure that they're right in the first place. If you're operating on an external DPO's own terms and conditions, if they've given them to you, you need somebody within the partnership or within the organisation that understands those terms and conditions and understands exactly what you're contracting with the DPO for how long, who's going to undertake the work, etc. And importantly, what the termination provisions are. I've come across them quite regularly. There's a group of companies out there that offer DPO services, and their termination period is 12 months notice. So you're getting to the end of your contract and you think, oh yeah, I need to think about terminating, and so you terminate in month 12, and they go, yeah, okay, we accept the termination, but you've got to keep us for another year, which may not be something that you want. So just a few tips about appointing and designating DPOs, and indeed running the system as a whole. Get to know who the DPO is before you engage them. Where is their experience? How long have they been a DPO? What training have they had? Where did they have the training? These are all relevant. Where will any liability fall? What does the contract say? Importantly, what doesn't it say? What are the termination provisions? What are the hours of work? When can you call on the DPO? If you're sharing them with other people, then, do you have the right to call them at any time, or can you only have them on the third Wednesday of a month, or what's the provisions? Who in your organisation is competent, and again, has the training, experience, skills and knowledge to monitor the work of the DPO? You can't rely on the DPO getting it right all the time. At the end of the day, it's you that gets the blame if they get it wrong. So you need somebody who's got enough knowledge to be able to supervise them and to monitor the work, and to then take action and question if you don't think it's right. Make sure either you, in the case of an employee, or the third party has got sufficient insurance, because that's what you're going to be claiming on if they get things wrong. And it's important to ensure that you've got the benefit of that insurance. Because often an insurance company, unless you've got that benefit, the insurance company will pay the DPO or DPO company directly, and you might not see that money, but you've had to pay it out to the data subject and their solicitors. So do you have the benefit of the insurance? Does it cover all the contingencies that might arise within your practice? And indeed the costs. I had a case, in fact it's not concluded yet, but we're just tying up paperwork, where the claim letter before action, it's called, came, and the data subject was claiming £7,000. And they were asking for lots of information. And so the practice gave them it. And then another letter would come for more information. And all that was happening was the information was going to the data subject, who was giving it to their solicitor, who was going, oh yeah, this is good, but we also need that, that, and that. Going back to the data subject, who went back to the controller. And after 6 months, they realised that they dug themselves into a deep hole, and had actually been given all the information to prove the data subject's case, and contacted us. And we looked at it and said, well, you know, all things being equal, there's a risk that they might win. And they said, oh, well, in that case, can we talk about settlement? Because, you know, £7,000, we can stand that. And I said, no, it's not £7,000. Sorry? I said, the claim is £7,000, but you've been corresponding with solicitors, albeit indirectly, for the last 7 months, and the legal bill's already £35,000. So you've now got £42,000 to pay out if you want to settle. And obviously the answer was, well, no, we don't want to settle for that. But that's what the claimant was now looking for. And they'd also gone out and got after the event insurance, for which the premium is payable in the event of a settlement. And the solicitor was also working on a contingency fee arrangement, no win, no fee, for which there was a 10% uplift on their fees. So even a very small claim for not a lot can very quickly rise in terms of cost, and you need to be sure that your insurance is going to cover that. In terms of the data subject, do they understand the finer points of the GDPR? In particular, things like data protection by design and by default. That is an obligation on you. You must implement data protection by design and by default. And if your DPO doesn't know what it is, then you've got very little chance of complying. Please bear in mind, they're the ones that are going to communicate with data subjects. They have the right, data subject has the right to talk to your DPO directly. And therefore, you want somebody who can communicate effectively with them. Also communicate effectively with the ICO, because the ICO is going to want to talk to them. And the last thing you want is your DPO becoming the star prosecution witness. And finally, can they effectively manage data protection, data subject rights? Because that, again, is something the DPO should be advising you on. Getting data subject access requests correct. It's not just a case of hand over their medical records, and there's a lot of other issues associated with the data subject access request, in addition to giving the information they want. And in fact, giving the information they want may land you in real hot water, particularly if you've given away third-party data, because that will be used against you. So what happens if you think there might be a claim? Well, the first thing to do is recognise it. Claims don't start as a claim form. They don't even start as a letter before action. Often it is something fairly minor. A disgruntled patient, disgruntled client. More often than not, disgruntled family member. Generally speaking, the patients themselves appreciate all the work you do for them. Family are a different story, and they will work away at the individual patient or client or service user until they agree to let the family member run a claim for them. So recognize that any complaints or any disgruntled comments could actually become a claim. Have an individual, a partner or a director, it's got to be somebody very senior who is now going to take that on and run with it. So we've got a single point of contact from start to finish. And that helps to prevent correspondence being lost, comments being made by various people that may actually be counter to each other. And it also allows you to manage things much, much better. So complaints, pre-action correspondence, letter before action, all issues that need to be dealt with. And unless you get them correct, can obviously lead to complications later on. You just need to be aware. I'm not suggesting it becomes a big issue. You will be advised in the event of a potential claim, but the way that the court deals with your failure to respond properly to requests for information, to delays, to adding burdens on the claimant, is that they award costs. So they award higher levels of costs to the claimant. And it's not really something you want to do. So you want to minimize the costs. And so by answering things quickly and keeping good records, that facilitates that. It also means that you don't inadvertently waive insurance cover, because your insurer turns around and says, well, no, you had a duty to do this, so you should have told us then, and you didn't do it, and we don't have to pay this claim. So important things to do. My advice to you is, as soon as you think you've got something that could turn into a claim, inform your insurer. In the vast majority of cases, it doesn't go on your claims record, therefore it's not going to affect your premiums going forward, but your insurer's aware and can help you manage. Whether it be the insurance company or your broker, if you inform your broker, they should inform your insurer. But that should help you manage things. And again, number one, it avoids the risk of waiving cover by not having informed the insurer at the earliest opportunity. But two, it gets you some additional help in managing things going forward. And as I said, it will go a long way to minimising claimants' costs should the matter go to court. Now, all of that is premised on the basis that you actually recognise a claim in the first place. And that means recognising a situation that could become a claim. Now, any correspondence you get should be seen by a partner or a director, who should then take a view whether this is just something minor and we can deal with it, or whether it's something we should take advice on. And advice taken at that stage, in terms of cost, is minimal. Yeah, that looks as though it might have legs. No, I wouldn't worry too much about it. This is the way to deal with it, and you hear no more. So make sure that all letters get to the relevant person, and indeed that they're handled and responded to. Please, please, please don't answer the letter yourself unless you've taken advice. That really is important, because as I said, this organisation thought they could deal with it themselves. They ran it for 6-7 months, and all they were doing on a weekly basis was giving the claimant more information to help the claim. It was a situation where the claimant solicitor needed to build up a sufficiently good case to take to the after the event insurers to get after the event insurance cover. For those of you that don't understand ATE insurance, it is cover against you having to pay the other side's costs if you lose. You pay a premium, and if you lose, the insurer pays the other side's costs, which can be substantial. And they charge a one-off premium at the beginning, and obviously they're not going to give insurance unless there's a reasonable chance that they're going to win. And so they want to see evidence. And so the solicitor builds up this evidence, gives it to the insurer, and the insurer says, yeah, okay, we'll cover that. That looks like a slam dunk case to us. If you answer everything yourself, then you may or may not understand what's going on, and you could well be building your case for them. I've already mentioned, but I'm going to mention again, inform your insurer as soon as possible, and follow any advice you're given. It's one of the most common ways of an insurer avoiding paying a claim is to say, you informed us, we gave you that advice, you didn't follow it, we're not covering it. And you're then left with the costs, one way or the other. In terms of recognising the claim, probably better I just go back a slide, my apologies. In terms of recognising a claim, 99.9% of claims these days start with a data subject access request. Please provide me with all my personal data, including, and we give a big list of documents that they want to see. Well, of course they want to see, because they are the documents they need to prove their case. A data protection claim is unlike most other claims in that normally the claimant has to prove negligence on your behalf. Data protection, they don't. All they have to prove is that you have breached your statutory duty to them, i.e. the GDPR or DPA, and that breach caused them harm. There is a bit more, but in essence, those two key points. Now, if you're giving them the evidence to show that your data policy wasn't quite up to speed, that you didn't have the relevant risk assessments in place, that your DPO hadn't been appointed, then you're giving them everything they need to prove their case. And so it is quite important that you understand that a simple data subject access request can be quite a dangerous thing if it's being used for the wrong reasons. So once again, what I would say is, if you receive a data subject access request, who's making it? Have they got a bit of a history here? And what's behind it? And that often will come from the types of information they're asking for. If in doubt, please just take advice. I'd rather I've got a quick email or a quick telephone call from you, and we go, yeah, no, that's fine. Just go ahead and respond to it. Or, whoa, this has got all the makings of a claim. Can we be a little bit careful on what we do and how we do it? And as I say, a very quick telephone call may be sufficient to put it to bed. Would your staff recognise a data subject access request if it comes in? Particularly if it doesn't say this is a data subject access request, because it doesn't have to. Any request for information that's personal data is a data subject access request, including verbal. So it can be made to anybody within your organisation. Would they recognise pre-action correspondence? As I said, the correspondence may be coming from the data subject, but it's actually being led by the solicitor. But rather than have a solicitor's heading, which alerts you straight away, it comes via the data subject, and therefore, oh well, do we have to answer this, or can we just forget it, or it goes around 3 or 4 people before it's recognised for what it is. So can it be dealt with? Would you understand what a letter before action is and what it means? There are very strict timelines for responding to correspondence in the pre-action phase, and failing to meet those requirements can incur costs on your behalf. It certainly can make it difficult to settle for favourable terms on your part. The key there is not be fooled and make sure you recognise everything. And again, playing with the technology in my case. I mentioned an individual way back at the beginning, and what I would say is it should be somebody very senior. They should try to identify exactly what's being claimed for from the correspondence, and that can be quite hard, and what the breach is, what is being alleged, and what damage are they seeking to identify, because that apart from anything else will put a bit of a value on the claim, and we'll know whether it's a relatively minor one or whether the claimant solicitors are going to want to run it to the High Court, employ barristers, employ experts, and costs overall are going to run into hundreds of thousands of pounds. Once you've got a suspicion, this individual should gather up all the information you've got and keep it in one place, so that it's not going to disappear. It's not going to get damaged or lost. Carry out an investigation. Just a low-level, quiet Are they right? Did we breach this? Is it possible that we caused this damage? And by all means, speak to staff, but please don't do so until you've taken legal advice, either via your insurance or your own solicitor. And two main reasons. Number one, that individual could become a witness against you. Secondly, if you take a statement from that staff member, that is not admissible in court. Even if they sign it, it's not admissible in court of itself, and it can be used against you. So take advice, please, before you take statements. Don't share details of the claim or anything surrounding it with anybody other than other partners or other directors. First of all, because you may waive legal privilege on it. Secondly, need to know is best. And it may be that all the partners don't need to know. You explain to the partners what's happened, offer to keep them updated, but explain that on a day-to-day basis, we're not going to be going back to them, and we're not going to have thousands of WhatsApp messages that all become disclosable, or emails flying back and forward. It just protects confidentiality and later on, because you're acting on the advice of a solicitor, legal privilege. For the third time, and I just genuinely cannot say it enough, please, please, please inform your insurer as soon as you've got any sort of suspicion. It is so easy for you to waive cover because you've not followed the letter of the policy. So speak to them and get advice. They're very good at early advice in particular, and follow the initial advice that you get. But I can't emphasize that again, for the same reasons, of course. Finally, just very key points. If you take nothing else away from today, please, please, please take away these. As controller, you're liable for everything. The DPO gets it wrong, then the only way you can recover is through the contract. There'll be a breach of contract. In the case of an employee, you're vicariously liable, and you'll rely on the contract of employment if you want to discipline them and or dismiss them. Otherwise, you wind up with an unfair dismissal and a wrongful dismissal and 6 months of tribunal. Generally speaking, the DPO doesn't get it wrong. As far as the ICO is concerned, it's the controller. Therefore, do your due diligence. Make sure it's your DPO, you've engaged them, they work for you under whatever terms. They can be shared, there is no issue with that, but have some sort of formal agreement with the ICB or the ICS about what the DPO will do and won't do. And what you'll find is very quickly that actually the DPO is probably not capable of doing everything you need them to do, just because they're doing the same for everybody else. And or they may not be competent, and they may not have the training, experience, skills or knowledge to do what you need them to do. Work with your DPO. Try and minimise the risks of a complaint, a claim, a data subject access request, etc. And be prepared to just receive an ICO's letter alleging breach out of the blue. The data subject doesn't have to come to you first. The ICO wants them to, and there is new legislation winding its way through Parliament at the moment that, if and when it comes into force, will require the DPO to contact you before they contact the ICO. But at the moment, the ICO can go straight to the DPO can go straight to the ICO without your knowledge. And you simply receive a letter saying that in the view of the ICO, you have committed a breach of the GDPR. Article 5 of the GDPR then moves the burden of proof onto you to prove that you didn't commit a breach, and as a consequence, you're not guilty of the alleged offence. Now, apologies, I've overrun a little bit, so we haven't got very much time for questions. If anybody's got any, fantastic, we'll deal with them now. If not, we're going to gather all the questions and we can respond to you via email with the answers. Apologies, it may take a little while because particularly if there's a lot of questions, I do have quite a big caseload at the moment, but I guarantee I will get back to everybody in due course. If you do have even a silly question, drop me an email. I'd much rather deal with it at that stage than later on when it becomes a major issue, and it's something that we could have dealt with a long time ago. In the event of an emergency, if something goes a bit pear-shaped, then please feel free to call me. The number's there, and if I'm not available, a message will get to me and I'll give you a call back as soon as I can.
Thank you, David. That was very helpful. There are just a couple of questions in there which we've got maybe a couple of minutes just to answer, David. The first one is just about, does everybody need a DPO? Because you mentioned about large organisations, but as general practices, they are obviously public authorities. So does every general practice need a DPO?
Yes, is the answer.
I thought you might say that.
Public authorities other than courts.
Yeah. So GP practices, if you've got a GMS contract or a PMS contract, you're a public authority, and there's an APMS, you may well be, and then you need a DPO, correct?
Yeah.
So the second question, could you comment on the difference between a Caldecott guardian and a DPO? That's a long question, but you might have a short form answer to that one.
It is. A DPO deals purely with data protection. Caldecott Guardian deals with the wider safeguarding issue of a patient. Now, there's a bit of overlap, but generally speaking, Caldecott Guardians, if they are involved in data processing in any way, shape or form, patient data processing, they can't be DPOs because they're conflicted. But the Caldecott Guardian is a much wider role than just data protection.
And it's typically also involved in management because they've got responsibility, yeah? Whereas a DPO wouldn't be.
It is generally not because they're a Caldecott Guardian, but because they're also a chief nurse or a partner or a GP.
And the last question in there is just, where would you find a DPO? Any thoughts?
Well, if you Google, you'll find thousands of them. There are quite literally thousands of DPOs.
I think the problem is around the quality, isn't it, of when it comes back to being an expert.
Which is why I raised the issue of the quality of the DPO.
Well, thank you, David, and thank you everybody for joining. The time's now, it's now past, so I'm conscious everyone's got to go back to their clinics, but thank you so much for joining. If you do have any questions, then please don't hesitate to reach out afterwards. You've got David's email there. Alternatively, you can send it, you can go via our website and come to info@drsolicitors, but always delighted to help, and thank you so much for joining. I hope you found that very useful, and it's a pleasure being here for you all.